Part 201 of the Natural Resources and Environmental Protection Act, or NREPA, is the section of Michigan law which deals with the liabilities associated with owning and operating contaminated properties in the state. It mainly governs the cleanup of contaminated properties and encourages redevelopment and reuse of previously contaminated lands. This part establishes liabilities. It allows for and authorizes litigation and empowers the courts to prevent further or future harms. Prior to the passage of NREPA, Michigan operated under the Michigan Environmental Response Act, or NREPA. This was the state of Michigan's counterpart to the Federal Comprehensive Environmental Response, Compensation and Liability Act, or CERCLA. Under NREPA, Michigan applied a theory of status liability. A person who was in any way responsible for dealing with or generating the waste had potential liability for any contamination resulting. This applied even if the person was in no other way responsible for the act. Part 201 of NREPA shifted the focus from simple contamination to intended future uses and potential risks and effects of exposure given those intentions. Liability was redirected towards the causative party rather than the party currently in control of the property. This was accomplished with the introduction of the concept of the Baseline Environmental Assessment, or BEA. In essence, Part 201 moved the liability line. If a person is responsible for an activity causing a release, then that person is liable. If a person isn't responsible for an activity causing a release, and the person acquired the property before June 5th, 1995, then the person isn't liable. If a person isn't responsible for an activity causing a release, and the person acquired the property on or after June 5th, 1995, then that person won't be liable, provided that that person performs a BEA and exercises due care. This section of the law dovetails nicely with Part 17 of NREPA, titled the Michigan Environmental Protection Act, or MEPA. This part authorizes courts to prevent conduct that harms the environment. Under MEPA, private parties may sue to protect the environment in much the same way as they have historically sued to protect property and contract rights. The statute modifies the traditional view that only public agencies protect the environment. At the governmental level, MEPA prohibits agencies from authorizing conduct that harms the air, water, and other natural resources, or the public trust in these resources. MEPA authorizes any person to bring an action, quote, for the protection of the air, water, and other natural resources and the public trust in these resources from pollution, impairment, or destruction, end quote. While the courts have held that defendants may challenge a plaintiff's standing in court and that the plaintiff must prove their standing if so challenged, MEPA is quite explicit in this regard. MEPA applies to all natural resources, both public and private. The Act is not limited to natural resources affecting land in which there's a public trust or a right of public access. In other words, MEPA may be applied to private properties, operations, and activities if they in any way negatively impact any natural resource. MEPA clearly applies to elements such as water, air, and soil. The courts have also held that the term natural resources includes trees and other plants, although not cultivated fields. Damage to these would be sought under the theory of nuisance. Likewise, a wildlife habitat, and not just habitat for endangered species, is also included in this definition. In short, by ruling that natural resources don't include any part of the human, social, or cultural environment, the courts have held that all else remains as de facto a natural resource. MEPA may also be applied to future conduct to prevent future or further harm from occurring. The plaintiff must show that the defendant's conduct, quote, has or is likely to pollute, impair, or destroy the air, water, or other natural resources or the public trust in these resources, end quote. If this is proved, the defendant may either rebut the plaintiff's proofs with contrary evidence or proof, quote, that there is no feasible and prudent alternative to defendant's conduct, and that such conduct is consistent with the promotion of the public health, safety, and welfare in light of the state's paramount concern for the protection of its natural resources from pollution, impairment, or destruction." End quote. Now we'll dive into the details of NREPA.